number 4, matter of Callen versus New York City Loft Board. Counsel?
Good morning, Your Honors. May it please the Court, Diana Lawless for the appellant New York City Loft Board. May I reserve 3 minutes for rebuttal?
You may have 3 minutes.
Thank you, Your Honor. This Court should reverse because it was rational for the Loft Board to reject the tenant's attempts to withdraw their loft law coverage application and direct further investigation into coverage. What the appellate division held here was that the only thing the Loft Board could do is to accept a withdrawal. But all that the Loft Board did was do something routine. It rejected the settlement, and its regulations allow it to remand.
So when you say reverse, you really just mean reverse that one part of the appellate division?
Yes, Your Honor.
2/3 of it, I would imagine you are amenable to.
We're amenable to everything it says about the agreement being reasonable for the Loft Board to find that the agreement was unreasonable under the law, and it should not be enforced.
And the remittal, right? Because they sent it back to the Loft Board for further proceedings.
Sure, but I believe it would be a different remittal. The remittal I believe that the current remittal would be that the Loft Board has to accept a withdrawal. The remittal, if we win, is that it would go back to further proceedings of adjudication of the coverage application.
Okay.
So, counsel, just to follow up on that for me, what happens? Let's say we agree with you, and the case goes back. What happens in front of the Loft Board?
Sure, so this is a threshold determination for coverage. The applications have been put in at the earlier stage, right before there was a settlement negotiation. There was a petition, there was an answer, the landlord and the tenants were not aligned on the different issues that had to be resolved as to coverage.
Let's say this never had happened, and that's where you were, right, in the beginning, and the tenant comes in and says, you know what, forget it, I want to withdraw my application. What happens?
Well, I think it's, if there had never been settlement negotiations?
Yeah.
If there'd never been settlement negotiations and the tenant would withdraw the application, I think under most circumstances, as my adversaries point out, the Loft Board does look beyond it, and there's reasons like, can you withdraw? And the only situations where really the Loft Board has had withdrawals accepted in the past have to do with situations where the tenant vacates the building or there's no more occupancy at issue. So in a case like this, the Loft Board retains jurisdiction over a case when the occupancy is at issue and needs to be resolved.
So other than those circumstances you describe, and again, forgetting this history of up and back, the parties come in, they say we want to withdraw, and they don't meet those special circumstances. The Loft Board says no, keep going. And then what happens if they don't show up?
Well, well, as my adversaries point out, if they don't show up, there is a situation where the Loft Board is allowed to say that there's a default for the tenants for not prosecuting their application. However, here, I think it's very significant for the court to focus on the situation here where we know, right, we know the reason, and the reason...
But again, I'm sorry,
Sure.
so stick with my hypothetical. So then let's say there's a default, but the Loft Board knows this is illegal based on what's already been presented, and now there's a default. Aren't you in the same circumstances you're in here?
No, Your Honor, we're not in the same circumstances because we're not being forced to accept that the only thing that can happen is to accept the illegality of the agreement, right? The agreement should not be enforced, but we're based, and a term of the agreement is the withdrawal, and the agency is not being forced to say, we can't do anything about your illegal agreement. We're going to have to basically put our stamp on your illegal agreement.
But why can't they, if they didn't want to withdraw anymore, I think they would have said that, why can't they agree just to withdraw outside the agreement now? We don't want to go back. We want to withdraw now. And if they did that in front of the Loft Board, you say, what could you do? You default them, but the end game is the same. There's no adjudication on the loft status, and potentially they're illegal.
I think the difference, Your Honor, is just the circumstances as this presented itself. It didn't present itself as a pure, we want to come here and we've seen the light, this is not a Loft Law building, we walk away. That's the Loft Board's not the Loft Board's problem. This became the Loft Board's problem because they're like, we're here before the Loft Board, we want to resolve this dispute. It's a threshold issue. We still don't, I cannot tell you whether or not these units, these tenants qualify for this protection under the Loft Law.
Counsel, I agree that it's a problem, but I think what Judge Garcia is getting at is that in some ways you're just sort of delaying the inevitable. He's put forth this scenario where the applicants just don't come back, and one imagines that the application is going to be denied based on their failure to appear to defend it, and now you're stuck again with an illegal living situation, and that has to be resolved. I'll propose another scenario to you. In this case, the landlord has raised the defense that the applicants don't fall within the correct window to qualify for loft law coverage. Let's say somehow you could compel them to continue litigating the application, and the ALJ comes to the conclusion, yes, indeed, they do not fit within the window. You're right back there. You're at the illegal situation, which you say that you cannot tolerate. So, you know, it feels like on some level that you're just kind of delaying the inevitable, or at least there's a good possibility that you're just delaying the inevitable with respect to this so-called illegal situation.
Well, Your Honor, but I'd like to take the second part of what you said with this hypothetical, that we're delaying the inevitable if there's not a finding of coverage. Actually, becomes the inevitable, right? The threshold determination of the Loft Board as an adjudicatory body is to determine if there is coverage, right? So there are plenty of applications where coverage is denied. The Loft Board's role is at an end there. So I think in your second situation, our role is fulfilled. But as to this idea that we're just delaying the inevitable, yes, of course, these parties are now saying, oh, well, we're just trying to walk around the loft law. But I think the importance here is a ruling from the court. If the court rules that, you know, these parties, the Loft Board has no choice and these parties have to walk away, then that's where we are. But if there's a reversal and the ruling is like the ruling of the second department, where the withdrawal can't be tolerated to allow them to waive the loft law, then it's maybe, you know, once there's a ruling from this court.
Can I
Sure.
ask you about a different scenario? Let's say you remand it to the or you remit it to the ALJ, and they maintain, the applicants maintain, we do want to withdraw. If the ALJ says, you know, something like an allocution, well, I can't force you to litigate this, but you should know that if you withdraw the petition, the application, it's going to be denied, and in my view, that's going to be an illegal tenancy, and you'll be subject to immediate removal by DOB. Would that fulfill the Loft Board's mandate to litigate through the issues to their natural conclusion?
I don't think so, because I think that they're full willing to say now that we want to walk away from it. I think the problem is in the idea of the agreement that they're putting forward, which is they want their own private, it's not like, oh, what you're saying, oh, well, we don't qualify. They say there's a risk they don't qualify, but they're like, either way, we want our private version of the loft law.
I get that, but I think the problem I'm personally having is that the Loft Board is expressing an intolerance with the situation that there are several scenarios that it has no power to address. The Loft Board cannot issue a C of O. The Loft Board cannot classify buildings as Class A or Class B residential. The Loft Board is not DHCR. You can't bring someone into rent regulation that way. And it's unfortunate that you don't have that sort of plenary power, but the result of that is there are going to be plenty of situations where you're going to leave people in illegal living situations, and there's really, unfortunately, nothing you can do about it. However, I mean, with all due, I say that acknowledging that the appellate division in this case actually did view that there was a path towards regulation, even with the denial. So, we could argue whether or how many cases end up with an illegal tenancy, but you can't prevent all of those from happening.
I think that's right, Your Honor, but I think that where we are is the way that this case was, the unique specific circumstances that were presented here, which is within the board's authority to review an agreement. So I think it's a very narrow case. And under these circumstances where the board was presented with an agreement, the terms are illegal, the withdrawal was a term, to say that the only thing the board can do is to accept the withdrawal goes against an explicit board regulation allowing that to happen, and to the spirit and the intent of the statute, which is to set up a process to allow this dispute to be resolved.
Well, counsel, what if we said, I'm sorry, may I ask, Chief?
Yes.
If we said, one, that's not before us, whether or not, I think, the argument being that whether or not it was rational to reject the agreement. So let's say, that's affirmed or not appealed, and our view would be, could this court just then send it back to the loft board to say, you can look to it, because you've, in essence, rejected the entire agreement. I'm sorry, I'm not articulating this well. The entire agreement, including the provision about withdrawal, which was with prejudice. So we send it back to the loft board, and there they can seek to withdraw the application. And then the loft board will decide it.
Well, Your Honor, they could always seek to withdraw the application, but I think that if a reversal in our favor would mean that the process would continue, so the board could continue to evaluate the application. Indeed, the board could continue to evaluate the terms of the settlement
And I guess the
agreement.
problem you're hearing up here is, how can they force them to do that and force them to keep litigating that, when in an ordinary case, they would just move to withdraw or default? So what would, I guess, be the purpose of sending it back?
Well, I think the purpose is that it establishes under the agency's authority as given to it by the legislature, that this statute isn't indifferent to the resolution of a dispute like that. The objection is for the buildings to become legalized, and the loft board has the say about how the process continues. And to say that the board's hands are tied at a part which is an early dispute resolution portion of a proceeding, as I said, it runs against what the board's regulations itself say, and I believe it runs against the spirit of the statute, and I think that that's what the Don Ben Court properly recognized.
Counsel, I'm sorry, if I can just interrupt you, I'm on the screen.
Yes,
Hello,
sorry.
Happy New Year, my apologies. So I just want to clarify something that I'm not sure is so obvious from the law, the regs, or what the position you have taken. Is it the board's position that if there's no application, you could go and investigate and determine on your own that this building needs to go through the loft board process? Do you have that authority? Or
No.
must you act only upon an application?
The way the statute's set up, it acts upon registration or application. So
Okay, that's what I thought. Okay, so now then let me ask you this. Let's take the hypothetical where there is an application. It's hotly contested. It's not so obvious what the outcome will be. And as you're already hearing from other members of the bench, the tenants decide to withdraw. Maybe they've reached a conclusion this is not worth it, or for whatever reason, not the one you have in this case necessarily. And so the loft board would then choose not to let them withdraw because, of course, you don't know whether or not it's illegal.
I think that this is an agency that's existed for 40 years. There's many administrative decisions. There's been, within the administrative decisions, there's been evaluation. There's a multiple factor test about that the agency looks at internally about whether or not the application should be withdrawn with prejudice. But I think in the largest set of circumstances, it's when there's no longer an occupancy. But yes.
Okay, so it's a yes, thank you. Okay, so then if you didn't let them withdraw, you would then proceed with an investigation without their participation?
Well,
Is that
I think
the
you're right. I think
position
my
of the
yes,
board?
so I'd say first of all, I don't have a categorical yes that we would let these people withdraw specifically. It's the specific case. But no, there is no further role for the loft board, right? They're left to the devices, right? They're left to the other harsher, right, remedies, because right now, for sure, this is an illegal occupancy. So they're kind of left to the wolves of the other more harsh government enforcement of a vacate order on the building and other things. So this is a presumptively illegal occupancy. They have no protection.
Let me ask you this. In a situation where there is another path, obviously the appellate division here thought there was another path, what would you do?
Well, there is no other path, so I'd like to focus on that part of it.
No, take my hypothetical,
Okay.
that there is an actual other path, that you're not disputing the other path.
I can't, I'm sorry, Your Honor, I'm having trouble taking your hypothetical because there is not another path.
I'm giving you a hypothetical where the parties, and even the loft board sees that there might be another path. I understand that you think factually and legally the path they've described for this particular building, this horizontal way of aggregating the units would not count, but let's assume for one moment there is. What would be the danger? Why doesn't that support the purposes of the sort of the rent stabilization law generally to allow them to pursue the other path.
Well, I apologize for fighting your hypothetical, Your Honor, but the path that they see a separate path to, they see a separate path to rent regulation. I don't see another path to legalization of the building. So if there were another path, then there could be another path, but I just don't see another path to legalization of the building. This is the only form that the legislature has allowed for this specific set of buildings, which are commercial C of Os, residential occupancy, no residential C of O, to convert while the tenants are living inside. So it's a very narrow circumstance, and we firmly believe that is the only path to legalization, whether or not DHCR has accepted or taken an application.
So
for
in your
legalization.
view, the sticking point is that they would continue to reside during the process?
Right, they would reside illegally.
So if they had some agreement where they would temporarily leave the premises while they pursued the path to legalization, that would not be a problem, correct?
They wouldn't, I don't believe in their circumstances they would even need the Loft law, because they wouldn't be living there. Nobody would be living there would be living
Yes,
without
but
residency.
the point is to change it, right, so that so that there is no barrier, that you have to do something. You're either going through the Loft law or you're going through some other path.
There would have to be another path that I don't see existing. That's right.
Okay, thank you.
Thank
Do
you,
you permit
counsel.
withdrawal in that last scenario?
Wait, Judge
When they
Rivera's
agreed
there,
to
I'm sorry.
vacate, would you permit withdrawal then?
If the tenants left the occupancy, we would allow withdrawal if the tenants were not occupying the building.
Sorry, Chief.
Thank you, counsel.
All right, thank you, Your Honor.
Counsel?
May it please the court, my name is Margaret Sandercock. I represent the tenants in this case, with the exception of Richard Fiscina. He was represented by counsel at the time he entered into the settlement here, but he is pro se at the present time. I will argue today that the decisions below by the Supreme Court in the Appellate Division must be affirmed, because parties must not be compelled to litigate loft law coverage against their will.
Counsel, I'm sorry to interrupt you, but it's the agreement to withdraw with prejudice is part of an overall agreement or is it separate?
It's part of an overall agreement, Judge.
So if they had the authority to reject that, what's the harm in now us sending you back to the Loft Board where you can move to withdraw your application?
Well, Your Honor, the settlement is in other ways very beneficial to my clients. It will prevent them from having to engage in perhaps several other rounds of litigation, because the Loft law is a litigious statute, and there are various points
But
at which
even
disputes
without,
can occur.
even assuming everything else is rejected in that settlement agreement? I mean, because that's not here, as I understand it. So all we're deciding here is, do you as tenants get to withdraw your application before the Loft Board with prejudice, assuming everything else in that agreement's no good? But you still want that. You still want to withdraw with prejudice.
Well, Your Honor, the Loft Board can't stop my clients from refusing to litigate the coverage
No,
hearing itself.
I get that point, but what is the difference then if this goes back to the Loft Board because that overall agreement was rejected and with basis, and the only issue now is you go before the Loft Board and you say, despite the fact that you've rejected my agreement, tenants, we still want to withdraw this application with prejudice.
Your Honor, I feel that the policy that the Loft Board occasionally adopts is quite arbitrary, because there's only been 6 rejected cases in the history of the Loft Board, and there's been at least 125 settlements that weren't rejected. It interferes with my ability to counsel my clients and other counsel's ability in the same regard. We can't prevent people from wasting money on litigation that they may not win, for example.
But this would be one proceeding. You're back in front of the Loft Board, or you file a letter or a stip saying, we move to withdraw with prejudice.
Let me try to go around it this way.
Well, you've tried so far.
The problem that we have with the city's position is that there are many other types of tenancies in New York City that are not subject to a C of O requirement. Tenement buildings typically don't have a C of O. Brownstone houses typically don't have a C of O. AIR,
Why
artisan
can't you
residence
argue
lofts,
this
don't have
all
a C of O.
Why can't you make this all all we're talking about is a process here. So why can't you make all of these, what sound like very sound arguments, to the loft board in a letter saying the tenants seek to withdraw their application with prejudice?
Your Honor, I feel that we've already done that because the agreement says we're going to withdraw it with
But
prejudice.
the agreement was rejected.
The Loft Board very regularly allows people to settle their cases without investigating the settlement in any way.
Counsel, I'm a little confused because you started by saying that you wanted to affirm the appellate division's decision, and one of the elements of the appellate division decision is that the Loft Board does maintain the right to reject settlements that it finds inappropriate. But now I think I hear you answering questions intimating that you want to be able to withdraw the petition, but you want to preserve the settlement terms that were arguably the quid pro quo for the withdrawal. And that would not be an affirmance, would it?
Your Honor, I believe that the decision of the appellate division is sufficiently favorable to the issues that are important to my clients and other loft law tenants that an affirmance would be appropriate. The appellate division found that there are other paths to legalization, and what we want is to be able to pursue one of those other paths for this building.
Well, I think the one thing that is indisputably true at this point is that if you were allowed to withdraw your application at this point without receiving coverage under the loft law, your clients are living in a building without a C of O, and there is no legal basis for their residence at the moment it happens. Is that not correct?
Your Honor, the Loft Board and other city agencies do always retain the discretion and the jurisdiction to remove people from buildings if they feel there's any actual risk. One of the problems in this case is that there's been no fact-finding that there's any actual risk to my clients. And as I had already briefly mentioned, there are various categories of other buildings in the city of New York that lack Cs of O. They are not supervised by the Loft Board to see if they get their C of O. We have an agreement here in place that a C of O will be obtained for this building. So I don't see how there's any harm that should be troubling the Loft Board relative to...
The point that is confusing me, which maybe is also what's confusing Judge Cantaro, is that the appellate division found that the agreement you have in place is against public policy.
I have to say, Your Honor, that I don't read the agreement that way. How I read the appellate division's decision in this case, and Dom Ben Realty, the second department decision, is of course completely different. But how I read the appellate division's decision in this case is that there is an alternative plan to, an alternative path to legalization for these tenants, and that they need to be allowed to pursue that. And that is what we seek to have affirmed.
Thank you, counsel. Counsel?
Good morning, Your Honors. May it please the Court, Magda Cruz, for the owner of this building. I would like to begin by clarifying that there is a C of O for my client's building, both the front of it as well as the rear building, which is at issue here. In fact, it is a mixed-use building. It provides for partial residential use.
Where is that C of O in the record?
It is not in the record, Your Honor. However, I indicated in my brief where it is in the Department of Building records, and I provided the citation. It's a public record, it's irrefutable, and the city doesn't contest that.
So is your position, counsel, I'm sorry, I'm on the screen, is your, hello.
Hello.
Is your position then that the issue is moot?
No, it's not that it's moot, because clearly the existing C of O is not a complete residential use for this building. It is only one floor, so therefore, the lofts at issue are technically categorized as non-residential on the existing C of O. But our position, Your Honor, is not that these units are illegal per se. There's never been a determination of that, Your Honors. This proceeding came before the Loft Board, and right from the beginning, there's never been a coverage determination. We don't know if these tenants would even qualify for loft law coverage. The matter was settled transparently in front of an ALJ. We are basically being punished by the city or the loft board for coming forward, coming together to try to legalize these units, to actually go through the process to render these tenancies as rent stabilized. These apartments today are registered with DHCR. These tenants are protected under the rent stabilization law. My client cannot evict them. Their rents are registered as legal regulated rents.
Leaving coverage out of it and going back to the C of O, is it your position that this mixed-use C of O that's somewhere at DOB actually authorizes the residents that are taking place right now, to the extent that if a determination is made that there is no loft law coverage or a withdrawal results in no loft law coverage, that this would not be an illegal tenancy?
I can only tell you definitively that to date, there has never been a Department of Buildings violation issued against this building for illegal occupancy. And I can also tell you definitively that there is a C of O for the rear building in which one of the floors permits residential use. It is a mixed-use C of O.
Can I try to get us back to what I think is the issue before us, which is whether it was irrational for the loft board to say, no, you can't withdraw the application?
No, absolutely, it was irrational.
Why?
Because, as my colleague indicated, as well as the questioning of the bench, when a tenant comes before the loft board with a coverage application, certainly at the beginning of the proceedings, there's no mandate for the tenant to prosecute it. And there have been many instances where tenants before the loft board living in admittedly illegal lofts, meaning there's only commercial use allowed for the loft, and they withdraw.
And have there been other circumstances where they haven't withdrawn?
I am not aware of a case before the loft board where they have precluded withdrawal.
That's a different question. That's a different question. What I'm asking is it a foregone conclusion that every time the loft board concludes that an agreement is against public policy, the tenant has withdrawn the case?
No, I
So we
cannot
don't-
say
So we
that.
don't know
Yes,
what the
but-
result here is going to be.
But we also don't know whether, A, these tenants would qualify for coverage.
Right.
We don't know that the occupancy is illegal.
Right, and so if we don't know those things, why
Right.
shouldn't we say, this goes back to the loft board, and you can make whatever arguments you want about that, or I move to withdraw?
They will most definitely, they will withdraw the application. And so this is really an act of
But why-
futility.
what-
And let me
I'm
just
sorry,
clarify quickly.
Counsel, I'm sorry.
I'm sorry,
Why-
my time is
Why,
up. May I?
if they are going to withdraw, why is it irrational, and the board, and they certainly have authority to send it back for further proceedings, why is it irrational to send it back and ensure that the tenants, without the benefit of the rest of this agreement, which has been rejected, now wish to pursue a withdrawal with prejudice, and just have them make that before the board? You're not precluded from doing that.
Well, at this time, the Supreme Court and the Appellate Division both held that there was no rationality to force a remittal for that process, to simply come before and say, I withdraw. But let me just say something also to clarify, based on your questioning. The Appellate Division did not find that the settlement agreement per se was against public policy. That's the argument of the city. In fact, we argued that it was not against public policy, that these units were now rent stabilized, that they would probably be deemed rent stabilized without the need even to go through loft law coverage. I cite in my brief the case of Milne, in which this court held that when units are subject to rent stabilization or rent control, more specifically, there's no need to go through loft law coverage proceedings. It is not an inconsistent situation for a building to be protected under the rent laws under one statutory scheme to forego loft law legalization process. They may not even need it. Accordingly, Your Honors, I respectfully request that this court affirm the appellate division's order to the extent that it held it was not irrational to allow these tenants to withdraw their loft law coverage application.
Thank you, counsel. Counsel, your rebuttal?
Thank you, Your Honors. To start, I just want to clarify the irrefutable certificate of occupancy. Even on page 7 of my colleague's brief, it says that it's a 5-story building approved for dwellings on the first story and for factory and storage on the upper floors. I'm under the impression that doesn't cover the current occupancies, and also I believe they pleaded that. I couldn't find the exact page, but I believe they pleaded that in their Article 78 petition. I think it's also acknowledges just the front building C of O in the agreement itself. Going to Judge, what Judge Wilson was saying, does it always is an inevitable? Do we know what's going to happen? You know, we looked into it. I don't know that we know. I know for sure there's 2 cases, the Parrish case and the Domben case, which were litigated through the courts. I know that neither of those cases were resolved with an ultimate withdrawal. One, there was no longer an occupancy, and the other is continuing. There was a registration by the landlord, and there's a continuing process before the loft law about that case. As your honors have noted, everything is together in the agreement that they, basically the appellate division said that you had to reject it. And I believe, I read the decision to say, as your honors have said in my opening argument, that the appellate division found it was rational to reject the agreement as public policy. So we only want the second part of that, which is the board's allowed to do what its rules allow it to do, which is to continue the process once the agreement is rejected, for the parties to come anew back to the loft board in changed circumstances. As Judge Garcia said, the circumstances have changed. The agreement's been rejected. The parties can come together now before the loft board and continue to hash out the issues.
Can I just ask you, and I think this might be a version of another question you got, if that were to happen and let's say the tenants default, they don't show up, would the board be authorized to continue its investigation under the authority that you referred to self-prosecute?
Oh, Your Honor, I don't think I didn't mean to mention anything about self-prosecuting, so I don't think that the board would be continuing an investigation into a building where there's no, because all the board does is write the issues from coverage through the C of O and the legalization. So I don't think there's an independent investigatory authority of the loft board to hash out whether or not buildings are covered or not without an application by
So if
someone.
the applicants default, the case is over? The
As so far as it
application is
concerns the
denied.
loft board, but not as it concerns the violations of the MDL.
Sure, but that's kind of outside your purview, that's what I was saying before.
Correct.
Counsel, can I just ask, how would you frame the issue that's before this court?
I think I'd frame the issue as whether it is rational, once the loft board rejected the tenant's attempts to, I guess, hold on, it's a little hard because there's 2 parts. I think that, is it rational for the board to be required to accept a withdrawal under its rules, under its authority, after it properly determined that it rejected a settlement agreement? So I think it's that limited issue on the withdrawal. And just to clarify one more point about what everyone's been saying about rent stabilization, I think rent stabilization and legal occupancy are 2 very different things, and I think that this court so held in the Chazen case.
Thank you.
Counsel, can I ask you a question? I'm on the screen again. So I just want to clarify the understanding, your understanding of what the appellate division decided on the settlement. Because I understand why the landlord's attorney is taking a different position on this. It does seem that the appellate division is saying that you're within your authority to reject a proposed settlement, right?
Right, so.
But once they've decided to withdraw, the authority's done. So yes, it was rational to reject the settlement. You could do that. But once they've decided to withdraw, you can't then deny their opportunity to withdraw. So I don't see that as saying that the settlement on its face violates public policy.
Well, Your Honor, I'm trying to flip through and find where they said, I guess I'll turn to the last page.
I'm looking at the sentence, perhaps I'm looking
Right,
at the wrong
page
part.
738.
Excuse me, counsel.
Yes.
Excuse me, as I see what they wrote, they say that we find that there's no valid reason for the board's refusal to grant the tenant's request to withdraw the conversion application. We do not agree with the tenants that the Loft Board's rejection of the settlement as a vehicle for conversion to rent stabilization has no rational basis.
Right.
I think let me finish. I think it's a recognition of the argument you were making before about your concern about people being in a unit that it's illegal, pure and simple, as this court has recognized before. But as the appellate division then goes on to say, but once they've chosen to withdraw, the authority ends. So yes, you could deny the settlement, but that's as far as you can go. I don't see that as sort of the express statement that you make it to be. It's just a recognition that, of course, it's not irrational of you to say, no, you can't enter an agreement that we're not certain will lead to a legal unit.
Well, Your Honor, I guess I just read it more broadly about the rationality of the agency's decision, but I think I want to just focus on the end point. The reasoning they gave for saying that the withdrawal has to happen is because the tenants relinquished their rights to proceed to conversion pursuant to the Loft law, and we see that as there's no choice. And the appellate division, you accepted the arguments that there was a choice, that stabilization equals legal occupancy, and I think that's clear from the appellate division decision. So I think the error is that there is not actually a choice, and that the Loft Board should be allowed to continue to resolve the issue.
Well, there is a choice, well, even under your view, there is a choice if they leave the premises, even under your view.
Sure, they can leave the premises, yes.
Right, so there is a choice. Whether or not you agree with the appellate division's assessment of the argument for why they think they can legally convert this thing is another story. But you can't say that there's never a choice. That strikes me as not correct.
No,
I mean, whether or not it's a valid one is another story.
No, I agree. Right. No, I agree, Your Honor. I guess we would say there's two valid choices. The two valid choices are leave or for the landlord to register. The other choice that exists that we believe is an invalid one under the MDL is to just walk away, ignore everybody, and take their chances on a vacate.
But I think the appellate division's decision is a narrow one in this sense. The appellate division's decision is, look, there's another path, and so if they want to withdraw and pursue that path, you cannot force them to litigate. You have no authority to force them to litigate. That is, to me, it's a very narrow decision.
And yes, and even accepting that, I think, Your Honor, I think that our position is that it's reasonable for the board under these very specific circumstances, these very narrow circumstances presented with this agreement where the terms are illegal and they want to withdraw, that it was rational for the board to make it was a reasonable interpretation of its own regulations that explicitly allow for a remand to let the remand happen instead of the appellate division saying you can't remand at all. The only thing you can do is let them walk away.
Okay,
To remand, as Judge Garcia has argued, for
Thank you,
withdrawal.
counsel. Thank you.